Good afternoon, everyone. My name is Hugh Morgan. I'm a partner in the construction engineering team here at VWV. And this afternoon, I'm going to talk to you about the Building Safety Act 2022. Slide, please. We're going to talk about just simply why the Act has become law, where it applies, when it comes into force, and most importantly, what does it do? Next slide, please. So the genesis of the Act came from Building a Safer Future, which was the independent review of building regulations and fire safety by Dame Judith Hackett. The final report was issued in May 2018. There haven't been an interim report in December 2017. As I'm sure you know, this all comes from the terrible tragedy at Grenfell. Dame Judith Hackett is an engineer, and many of her recommendations are now becoming law through the Building Safety Act. Slide. So, when and where? The Act received royal assent on the 28th of April this year, and there's a transition period for bringing it into force, which is quite convoluted, I have to say. So some of it came into force on 28th of June 2022, and it'll go through and it'll all be enforced by October 2023. And I'll explain which parts are enforced as we go along. Where does it apply? Well, it applies in England and Wales, and some sections apply in Scotland and some in Northern Ireland. Next slide, please. And what? Well, the Act does a number of things. Firstly, it makes changes to the Defective Premises Act 1972. It's going to bring into force Section 38 of the Building Act 1984, which has been sitting there dormant since 1984. It has particular focus upon high-risk buildings, which are high-rise buildings, anything over 18 metres or 7 stories, and I'll come on to how that's defined later. And for obvious reasons, that's a lot of the focus of the Act because of the Grenfell tragedy. Dame Judith Hackett recommended that there should be a golden thread of information that demonstrates that any building meets building regulations, and that idea has been brought through into legislation. The Act creates 3 planning gateways, and I'll explain what those are as we get to them. And the Hackett report concluded that the building control regime for the application and enforcement of building regulations in this country was effectively broken. And as a result, there's going to be a new safety regulator. And I'll explain how they come into being in a moment. Slide, please. So, the Defective Premises Act, well, this has been around for, you can see, many years. But it's worth just understanding what the Act does if you're not familiar with it, because the changes to it then make more sense. So, Section 1 is this is the guts of it. A person taking on work for or in connection with the provision of a dwelling. So, a person taking on work for or connection with the provision of a dwelling owes a duty. So that's a developer, an architect, an engineer, a project manager, or me, just if I happen to be taking on work in connection with a dwelling, not as a lawyer, but as a construction, or just as an individual doing my own house I'm going to sell. It's everybody. It's got a wide range of people who owe a duty, and they owe that duty to every person who acquires an interest, legal extra in the dwelling. So a landlord, a tenant, they receive the benefit of that duty. And it's to see that the work is done in a professional manner so the dwelling will be fit for habitation. So happy days, you think? So this legislation has been around since 1972. Why do we need to alter that? That gives everyone a right, an enforceable right to make sure a new house is fit for habitation. But the problem with that is, or the limitation of that is, it relates to new buildings. And if we move to the next slide, I'll show you what happens with the Building Safety Act. So the Building Safety Act is going to change this by creating a new section 2A, and the significant part of it, it doesn't actually do it this way, but the significant part of it is that it increases the duty to include refurbishment and rectifications. So, for example, the duty now extends to a person taking on work for or connection with the provision of or to any part of a dwelling. So that means if you put a new roof on a dwelling, if you put new cladding on a dwelling, if you put new flooring in a dwelling, you put new wiring in a dwelling, then you are now covered by the Act. Next slide. The significance of this will be seen in a moment. So the DPA, as we call it in the trade, that has a 6-year limitation period. But the Building Safety Act increases that to 15 years from last June. So if you take on work in connection with a dwelling from now onwards, you'll be liable for 15 years. And so if you put new cladding or new roof on a building, you'll be liable for 15 years. But most significantly, if someone has a claim that accrued before last June, then that can go back 30 years. So if there was a new roof or a new cladding or new wiring in a dwelling since in the last 30 years, then that becomes actionable by virtue of this Act. So that is a really revolutionary part of this legislation. So while I let you let that bombshell sink in, I'll tell you a bit more about building regulations. Next slide, please. So there is a change to the guts of building regulations. Now, many of you know I could be teaching my grandmother to suck eggs here, but building regulations, they come from the Building Regulations 2010, which is an SI. SI means statutory instrument. It's secondary legislation, which is brought into law by virtue of the Building Act 1984 and the Building Approved Inspectors Regulations. So that's where our building regulation regime comes from. It implies terms into the suitability of working materials. Under the regulations, further approved documentation can be delivered, which give more detail to all aspects of working materials. And the one we're most interested in recently is the approved document B, which deals with fire safety. It's going to extend the requirement for external walls for the classification of external walls to be A1, non-combustible, or A2. The way the classification works, it goes from A through to F, A1 being the least combustible, F being the most combustible, and A2, S1, DO. The S relates to smoke, and the D relates to droplets produced once involved in a fire. So it's increased. Our building regulations have been increased by the Building Safety Act. Now come on to the building. Next slide, please. Building Act, Section 38. So this was not brought into force in 1984. It's been sitting there for 38 years. It's not in force yet, a point I'll come to in a moment. But Section 38 says, breach of a duty imposed by building regulations. So we've seen what building regulations do. Breach of a duty imposed by building regulations, so far as it causes damage, is actionable. So if there's a duty imposed by building regulations and you suffer damage because it's been breached, then that's actionable. And then the caveat is except insofar as the regulations provide otherwise. So some of the regulations provide specific remedies, different remedies. But this is a very wide-reaching duty. Damage in this instance is death or personal injury. It's a little bit strange. The government produced a fact sheet on this provision in November 2021 from memory, and then withdrew it in July 22. And this clause, the Building Safety Act refers to this provision, but it doesn't bring into force yet. And so we're not quite sure what the government's going to do with it, but it is very far-reaching if it does come into force. It applies to all buildings, not just dwellings. So any builder, developer, carrying out building work of any sort to any building, if there's a duty imposed by building regulations, which there most certainly will be, and that causes death or personal injury, the person who suffered has a claim against them under statute. That's what it will do. That duty will last for 15 years. Now, the limitation period has been changed, but this particular clause hasn't come into force yet. This transitional period we have between last June and next October, it requires a lot of the provisions of the Act require what we call secondary legislation to be put in place, so further statutory instruments and other regulations, and quite a lot of that is in consultation at the moment. So once that consultation finishes, then we'll have more sort of meat on the bones of this Act, and we'll know which further bits are going to be brought into force. What we do know is there have been specific about the high-rise buildings, which is in the next slide. So high-rise buildings is a new category of buildings. It's anything over 18 meters or at least 7 stories. And there's a little diagram there which shows you how you calculate it. It's from the very lowest point to the top floor, or the floor of the top story. And the way to remember this is that the logic is that if you're a fireman, you start at the very bottom and you walk all the way up all the sets of stairs, and then when you put your foot on the landing of the top floor, that's as high as you're going to go. That's where you're going to find people. So it's really to do with how far a fireman has to travel vertically upwards. That's what it's about. So you don't count the height of the top story, and you don't count any plant or materials on the top of any stuff on the top of the roof. Now, this isn't in force yet, but when it is, part 3 is going to deal with the design and construction of all high-risk buildings, and part 4 will deal with the occupation. And we don't know some of the details of this yet because it's not been produced in secondary legislation, but we'll come to that. Next slide, please. Okay, so these are the planning gateways I was talking about. The first one came into force last August, and on a planning application for a high risk building, you need a fire statement at the planning application stage. And then before you start construction, BSR, sorry, so many mnemonics, that is the building safety regulator. He has to provide approval. And before you occupy, he has to run an assessment and give you an assessment certificate, then the building can be occupied. At present, only the first gateway is in force. In section 2, as part of the approval process, you have to pay a levy, which I'll come on to later, but that's, you've probably heard about the levy. It's quite contentious. It's been in the press quite a lot. Next slide, please. The golden thread of information. So I mentioned this is something that the Hackett report recommended. It's information that demonstrates the building meets building regulations, and that's something that should be maintained at all times by the approved person, who I'll explain who they are in a moment, and should be made available to all interested parties. It's just knowledge and transparency about the safety of the building. Next slide, please. And the Act creates some duty holders during occupation. So the building safety regulator I've mentioned, they are in effect the new building control for buildings dealt with by the Act, and have wide-ranging powers. And another duty holder is the principal accountable person. So it's either going to be the owner or the person responsible for the building or maintaining the common parts. And they have the legal burden of making sure the building's safe and for responding to any incidents, notifying any incidents to the building safety regulator, carrying out the building assessments. Next slide, please. And enforcement. Remediation orders they can oblige a landlord to remedy a building, and remediation contribution orders, they can require previous landlord or developer to contribute to the remediation of a building. Building liability orders, that's quite a novel enforcement procedure. This will allow the court to issue a liability order not only against the person who built the building, but if that was an SPV, a special purpose vehicle, that is perhaps insolvent, then they can go behind that special purpose vehicle and issue an order against the parent company or a sister company or a related company, which is that is very novel and very far-reaching. The building safety levy, again, that's not enforced yet, but when the second gateway comes into play, that will be operative. At the moment, that's still under consultation. I think from memory, the consultation ends in February next year, and that is the building safety levy. Is the idea is that to build a new building, you will pay part of the levy. You pay into the levy. The levy will be there to pay for remediation of buildings where there is no developer any longer around, what they call orphaned buildings, where they can't find the original developer and it needs remediation. Again, that's been in the press quite a lot. The building safety pledge, that is whereby existing developers pledge that they will rectify buildings that they were responsible for in the past, and again, that's not enforced. Also, there's going to be terms implied into relevant leases. Relevant leases are 7-year leases relating to these high-risk buildings, and the implied terms will be to comply with the aspects of the Act and comply with building safety requirements. So there's quite a lot that's going to come into force later, and I'm hoping, look forward to being invited back to talk to you about these other elements over the coming months. Thank you very much. That's me done. I'm very happy to answer questions at the end, and I'll hand you over.
Hello, everyone. Just by way of a quick introduction, my name is Sonali Shah, and I'm a solicitor in the commercial property team based in the Watford office of VWV. Today, I'll be talking to you about some of the considerations to bear in mind when negotiating an overage. Before I start, as you mentioned, we'd be happy to answer some questions. So if you have any questions in relation to the content of this webinar, please feel free to pop them in the Q&A box below. Next slide, please. Overage, which is sometimes referred to as clawback or uplift, is a mechanism which allows a seller to benefit from an increase in the value of land after it has been sold. Practically, this will involve the buyer making a further payment to the seller to represent a proportion of the increase in value. There will usually be some sort of a trigger event which will oblige the buyer to make the payment. When should parties be thinking about overage? Overage is usually considered where the land being sold has development potential. For example, where there's a reasonable expectation that a valuable planning permission may be granted in the future in relation to that land. Some sellers, such as public sector bodies or charities, are also under an obligation to sell any land they own at something akin to the best price reasonably obtainable. So overage provisions can be quite useful to have in such situations, particularly where the seller is worried about the embarrassment of having undervalued land at the point of sale. Is overage all bad news for buyers? Not necessarily. Buyers could use an overage as a strategic way to reduce the initial purchase price payable for the land, as the obligation to pay overage could be factored in at that point. As overage may never actually materialize, this could result in a long-term saving for the buyer. So should sellers always try to negotiate an overage when they're selling land? Again, not necessarily. If the land they're selling does not have development potential, or there are no regulatory reasons really for them to have overage provisions, then it might be a waste of time and money to try and negotiate an overage. Next slide, please. When you're negotiating an overage, it is important to carefully consider how the overage mechanism will work from start to finish. It may be worth engaging a surveyor or land agent to act on your behalf in relation to the negotiations. There are four main factors to consider when you are negotiating an overage. The first is how long is the overage period? The second is what is the trigger for payment of the overage? The third is how will the overage be calculated? And the fourth is how will the overage be protected? We will touch on each of these in a little more detail with a particular focus on triggers over the course of this session. Next slide, please. The length of overage will be a matter for the parties to decide, though generally a seller will prefer to have a longer overage period while a buyer will want a shorter one. In practice, the buyer and the seller will probably meet somewhere in the middle. So if the land is going to be developed, then the overage period could be decided by reference to the length of time it could possibly take a buyer to obtain planning permission. That's just one example. The length of the overage period will therefore need to tie in with the trigger event for the payment of the overage. If the trigger is a grant of planning permission, then this will not need to be, the overage period will not need to be as long as if the trigger was the sale of the units developed on the land as a result of the planning permission. Next slide, please. A trigger event or events will need to be agreed between the parties. This will usually be something which increases the value of the land. Examples of common triggers are grant of planning permission, implementation of planning permission, sale or disposal of the relevant land at a higher price. And this is particularly useful where the seller, such as a public sector body, is concerned that its buyer will make a quick profit on the land. Another trigger is the sale or disposal of individual units on a development. Starting with the grant of planning permission as a trigger, this is something the seller is likely to want as it would be more achievable within the overage period where the relevant land is being developed. A buyer in general is more likely to want the trigger to occur further down the development process where the value in the land is a little more realized, such as implementation of planning permission or even better disposal of the units on the development. If the grant of planning permission is a trigger, a buyer may want to consider incorporating provisions such that the planning permission is unchallengeable. So the trigger would not just be the grant of planning permission, but it would be the grant of planning permission which remains in place following the period for judicial review. If implementation of planning permission is the agreed trigger, then the parties should consider what should happen in the case planning permission cannot be implemented. In the London and Ilford Ltd and Sovereign Property Holdings Ltd case, a buyer had planning consent to construct 60 flats on a site in Ilford. However, not all 60 flats could be constructed as this would contravene building regulations. The Court of Appeal did not take too kindly to the buyer's argument that it did not have to make an overage payment. It considered that planning and building regulations were two separate regimes, and the parties had agreed the trigger by reference to the grant of planning permission and had made no provision for the requirement of building regulations approval when negotiating the overage. Though in this case, the trigger was the grant of the planning consent, this will have implications for when the trigger is implementation. Next slide, please. If the agreed trigger is sale or disposal of the land itself or individual units following development, then the parties will need to carefully consider what actually constitutes a disposal. A seller will be keen to have a wide definition of disposal so as to trigger the payment of overage in a range of circumstances while also preventing the buyer from exploiting any loopholes in the definition of disposal. On the other hand, the buyer will want to be able to deal in some ways with the land without triggering overage payments, for example, by charging it to a lender who will be funding the development. Another thing to consider is that the trigger might be the disposal of the land, but what happens if the land is owned by a company and that company is sold? As the land still remains within the ownership of the company, this might not necessarily constitute the disposal of the land under the relevant definition. Therefore, the buyer could simply sell the shares in the company to avoid paying overage. Where the trigger is the sale of individual units on a development, the party should be clear about what a unit is. In the case of Harris and Berkeley Strategic Land Ltd, the seller was entitled to a further payment of £55,000 per unit of residential accommodation over an aggregate of 290 units on the site. A further planning permission had been obtained for a care home development containing 60 flats with associated communal facilities and an additional 15 flats which were designated as sheltered accommodation with separate access. It was accepted that the 15 flats were permitted units of residential accommodation, but could it be said that the care home included 60 units of residential accommodation? The developer argued that the care home was a use within Class C2 of the Town and Country Planning Use Classes Order 1987, rather than a Class C3 dwelling house use, so it was not appropriate to refer to parts of a care home as units of residential accommodation. The judge considered that the contract itself did not distinguish between the two types of residential accommodation in the two classes, C2 and C3. Therefore, it was necessary to assess both the physical character of what the planning permission permitted and the use to which the permitted development would be put. The judge held that the wording of the contract in referring to units of residential accommodation included residential accommodation within Class C2, so that the overage payment related to the 75 units of residential accommodation, that is the additional 15 flats plus the 60 care home units. So a very hefty overage payment to be made by the buyer in that case. Generally, the sale of the last unit on a development is not usually a good trigger from the seller's perspective. What if the developer sells all units but deliberately does not sell the last one to avoid paying the overage? If the sale of the last unit is to be the trigger, then parties may need to consider imposing an obligation on the buyer to use its reasonable endeavours to sell all units on the site. Next slide, please. There are various methods of calculating overage payments, as the parties will essentially be looking into a crystal ball when trying to negotiate overage. It is advisable for each party to consult a qualified surveyor who can advise on which type of calculation would be most appropriate for that transaction. Common bases for overage calculations include an agreed percentage of any uplift in the value of land, a fixed sum payable for each unit developed on the land, and this is usually by reference to an excess of a base number of units, an agreed percentage of the buyer's profits from the land. Whatever basis is chosen, parties should ensure that the calculation actually works. It is generally better to use numerical formulae for the calculations rather than words, much as we lawyers love our words. And it is advisable for the parties to include some worked examples within the overage agreement so that there is no doubt as to how the calculations should be made. Where the overage will be a percentage of any uplift in the value of the land, then the parties should be very clear about what the base value and the enhanced value of the land are, and ensure that this is sufficiently clear in the overage agreement. Next slide, please. The parties will have a binding contract with regard to the payment of overage. This will not be sufficient for the seller usually. Covenant to pay overage is only good as the person who has given it. Therefore, the seller is more likely to want to protect its entitlement to the overage by way of other means. The most commonly used method of protection is a combination of the chain of covenants and of restriction on the title to the land. This will involve the buyer covenanting with the seller that any future owners of the land will also covenant with the seller on similar terms to the buyer to pay the overage upon occurrence of the agreed trigger event. The seller obtains further protection by putting a restriction on the title to the land so that no disposal of the land can be made without its consent. which it will not provide unless it has received a deed of covenant from the future owner. Restrictions are a very useful tool to control what happens with land, and as such, they're very popular in the context of overage. As an alternative, the seller could take a legal charge over the land. The legal redemption date would be upon occurrence of the trigger event, and if the buyer defaults and does not pay the overage on time, then the seller could exercise its power of sale under the charge. However, this may not be a suitable means of protection if the buyer is seeking to obtain funding for development, as the seller's charge on the title will be unacceptable to most lenders. As a seller, it is also worth considering whether you should take security for the overage payments, such as a parent company guarantee or a bond, particularly if your buyer is a company which has been set up primarily for the purchase of the property, or in other words, an SPV. Next slide, please. The general difficulty with overage is that it is based in the future but has to be negotiated in the now. It relies on an event occurring in the future, resulting in a future increase in the value of the land. Disputes often arise where the terms of the overage agreement are unclear or where possible eventualities have not been properly considered by the parties at the time of negotiation. So how can the parties get overage right? First, they should think carefully about how the overage will work from start to finish. Bottom out all the details, such as the length of the overage period, the trigger, the calculations, and protection of the overage at the negotiation stage, and ensure that these are properly documented in the agreed terms. This will save time and money when the overage agreement is being drafted, and it will also prompt legal advisors to seek instructions on matters which are not clear from the agreed terms. Secondly, the parties should seek proper advice. Overage can be an extremely complicated area, and it is worth seeking advice from a qualified surveyor with regard to determining current and future land values upon which to base calculations. Parties should also be obtaining appropriate legal advice in relation to the instrument which is recording the overage. Overage will be negotiated in the present with a view to the future, and however hard the parties may try, it is not always easy to predict the future, and particularly what complications may arise then. It is important that the parties fully recognize that this risk does exist when they are trying to negotiate an overage. Thank you for attending this. I'll now hand over to Richard Van Jones to continue the session.
My name is Richard Van Jones. I'm a senior associate in the commercial property team here at VWB. And today I will take you through a quick canter through case law update. So we've got four cases to consider, all of them quite interesting ones, actually. So the first one is a C. Next slide, please. Is Bugsby Property LLC and LGIM Commercial Lending Limited. This is a case concerning the enforceability of an exclusivity agreement, which is made between a potential purchaser of the Olympia Exhibition Centre in London and a lender. And the background of this is that Bugsby was interested in purchasing the exhibition centre and approached LGIM to negotiate the terms of a loan to help fund it. As a precondition of revealing its confidential plans to the lender, the parties agreed an exclusivity agreement in which LGIM confirmed it would not deal with anybody in relation, or any other third parties, in relation to the purchase of Olympia for a period of 18 months. Bugsby eventually submitted a bid as part of a joint venture, and this is funded by Goldman Sachs. Within the exclusivity period, LGIM subsequently became involved with a rival bidder, U Capital Limited, and U's bid was ultimately successful. Bugsby made a claim against LGIM for breach of an exclusivity agreement, giving rise to the loss of the chance of acquiring the exhibition centre. Now, LGIM admitted breaching the exclusivity agreement, but maintained that their involvement in arranging finance for U Capital made no difference to the claimant, and that U Capital's bid would always have been successful. So the court was asked to review the authorities concerning chance and loss of a chance in relation to loss caused by a breach of contract, and reached an overall judgment, having understood the detail of the case, but also having stood back to see the situation objectively. So they effectively said it was a holistic approach was taken to assessing this particular claim, which was found to have merit. And the court set out its reasoning as follows. It's relatively tortuous, but it's worth running through. Point one, it was a near certainty that the seller would have been prepared to sell the exhibition centre to Bugsby. Point two, the seller's interest was in the level and achievement of the price rather than the identity of the buyer. And it was also a near certainty that Bugsby would have been able to finance its bid. In addition, there was a near certainty that U Capital would have been able to finance its bid without LGIM's involvement, given enough time. However, it would have needed, in the words of the court, another few weeks to be ready. The greater chance on balance was that the seller would have waited for U Capital. The position was complicated because U's terms with the hypothetical lender other than LGIM might have changed and might not have been so attractive to the seller. The position was very close because if U was partnered with a slower lender, then the seller's interest in the Bugsby bid could be expected to have increased, as could Bugsby's drive to complete. So stay with me, we're nearly there in the chain of logic. So there was a real and substantial chance that Bugsby would have won the race in the absence of LGIM's involvement. Presumably also LGIM had a bit of a heads up, having already considered Bugsby's bid in the first place. So the court assessed the chance of Bugsby winning on timing to be 40%. They then applied some fairly tortuous maths that you can read in the judgment if you want, quite beyond me, but the end result was that Bugsby was found to be entitled to 35% of the acquisition, debt arrangement, and annual investment fees which it had lost the chance to earn, together with 35% of the investment value which it had lost the chance of acquiring. And that totaled very nearly £15 million. So essentially, the key finding of this case is that exclusivity agreements are binding, even if the claimant eventually chose to proceed with a different lender. I got so caught up in that, I forgot to say next slide, please. Thank you very much. So this is the second case. And it's, you can see Pretoria Energy Company, Chittering Limited and Blankney Estates Limited. Again, a substantial claim, £56 million dispute here. And it hinged on the enforceability of heads of terms between parties. In particular, but not exclusively, whether or not an exclusivity period within the heads of terms, which we'll all have encountered quite frequently, was binding. So the background to this is Pretoria Energy was a company that operated anaerobic digestion plants, which essentially produce gas and electricity. You feed them with organic matter, and that's what you get at the end of it. Blankney was a farming business, and in 2013 they entered into negotiations with a view to granting Pretoria a lease over some farmland to build one of its plants. A document, which was titled Heads of Terms of Proposed Agreement, was drafted, and that contained provisions relating to a proposed 25-year lease of the land at a rent of £125,000 per annum. The heads were subsequently amended to include what was called an adherence amendment, and that stated that the parties agreed to adhere to all of the terms of the heads of terms until the final agreement, meaning the lease, was signed. At the same time as that amendment, there was included a lockout provision in the heads of terms, under which the parties agreed not to enter into negotiations with anyone else to the detriment of the heads of terms. And this lockout provision had an expiry date of July 2014. Subsequently, the heads of terms were once again amended to remove the adherence amendment. And this was after Blankney's solicitor pointed out it was inconsistent with the lockout provision. The parties signed the final heads of terms in November 2013, but negotiations stalled during 2014 and no lease was ever entered into. Notwithstanding the lack of progress, Pretoria spent money on securing a crop intended to be fuel for the plant and generally conducted themselves as though the lease was a certainty. However, in November 2014, so after the lockout expiry date, Blankney agreed to sell the land to a third party. Pretoria brought a claim that Blankney was liable for breach of contract because the parties had agreed under the heads of terms that Blankney would lease the land to Pretoria, and Pretoria had acted and spent money regarding its future plant in reliance on that agreement and on that representation. Blankney in turn argued that the heads of terms did not represent a binding contract in terms of the potential lease, and that the only enforceable part was the lockout provision, which had expired. The verdict was that the court found in favour of Blankney. Again, they set out the logic, and it's a useful one to see because there are quite a few points to this, all of which I suspect many of us will encounter fairly frequently. So the parties had not intended the heads of terms to have contractual effect, except in relation to the lockout provision, which was agreed by both parties. The reasons for this conclusion were as follows. Number one, the proposition that the parties had agreed a binding contract for the grant of a lease was incompatible with the lockout provision. And this clearly implied that after July 2014, the defendant would be free to enter into negotiations with third parties, including for the grant of a lease at the site. That would not have been possible if Blankney had already agreed in binding terms to grant a lease to Pretoria. Second point was the inclusion and then subsequent removal of the adherence amendment was significant. The wording of the amendment would have been a strong signal of an intention of the parties to be bound by all the provisions of the heads of terms. Though interestingly, we'll never know, but if the heads had been fundamentally inconsistent and Blankney's solicitor had not pointed that out and had them amended to essentially work in a consistent manner, then it may have been an argument down to which was intended to be the prevailing clause. But as it turned out in this occasion, the adherence amendment had been removed. By removing it, because it was not consistent with the lockout provision, the parties had objectively agreed to a period of exclusivity rather than giving contractual force to the entirety of the heads of terms. Third point is the parties had agreed that the proposed lease should be contracted out of the Protection of the Landlord and Tenant Act 1954. And by inserting a clause into the heads of terms that it would be outside the Act, Blankney had signalled that it did not intend to enter into a binding agreement until the contracting out process was entered into. So if these heads were genuinely to have taken effect essentially as an agreement for lease, then the LTA protection would have to have been expressly contracted out of prior to the signing of the heads of terms. Had the heads of terms essentially functioned as an agreement for lease, then I'm just repeating myself, they would have to have been excluded from the Act before the signature. And finally, the parties had not agreed all the terms of the lease, and in particular, whether the plant would need to be removed from the site at the end of the lease. That was an issue of significant commercial importance without an obvious single answer. And in fact, both parties had recognised that in the heads of terms, which said reinstatement provisions to be agreed between the parties, or wording along those lines. The heads of terms also crucially were described as being heads of terms of a proposed agreement, and clearly envisaged a future formal and binding agreement. And that tended to suggest that the parties contemplated they would not be bound until a future document had been signed. That document being, of course, the lease itself. Now, regarding Pretoria's claim that it had relied upon the heads of terms and subsequently incurred cost and loss, the courts held that the subjective belief of the claimant was irrelevant. In all the circumstances, the evidence of reliance was not sufficient to displace the clear indicators that the parties did not objectively intend the heads of terms to be binding. So the key points to take away from this are, first of all, that a clearly drafted lockout provision was binding and would have been binding and enforceable on the parties had there been a breach of it. And had there been a breach of it, the outcome of the case might have been very different. Point two is, unless very clearly drafted to be binding on the parties, and in which case a formal agreement for lease would seem to be far more suitable, heads of terms do not create legally binding agreement between the parties. And point three, as ever, is it's all in the drafting. So detailed and precise drafting is required when creating heads of terms, and it is almost all of the false economy to do a quick and dirty set of heads, especially when you're in relation to a very substantial and very high value agreement such as this one. Next slide, please. And next slide, please. These slides, obviously, massively condensed. I'm giving you a bit more detail, but hopefully the slides themselves will act as an aide-memoire. So the next case is to do with restrictive covenants. And it's Davies, Gilbert, and Goucher, and others. In this case, the court reiterated the principles to be applied when determining whether a landowner whose land benefited from a restrictive covenant had unreasonably withheld their consent to development on neighbouring land. In particular, it outlined the approach to be taken where the covenantee was alleged to have taken account of irrelevant considerations, and it rejected a proposition raised by the defendant that a refusal would generally be unreasonable if it was based on a concern that could be neutralized by imposing a condition on the development. Although I've been scratching my head a bit and seeing how you could impose a condition on a development that you've built that reflects a restrictive covenant that says don't build anything. The background was that the defendant sought the claimant's consent to the construction of 2 dwellings on their land. Claimant refused on 2 grounds. First being the development would have a detrimental impact on the amenity value of the whole of his estate, and that is land beyond the benefiting land under the terms of the restrictive covenant. And the second ground for refusal was it could threaten the future use and commercial value of the benefited land, as distinct from the estate. The defendant claimed this refusal was unreasonable and just cracked on with the construction work anyway, and subsequently Mr. Davies Gilbert took legal action to prevent this. The verdict reached was, in deciding whether to grant consent, the covenantee, Mr. Davies Gilbert, had to take account of relevant considerations and exclude irrelevant ones. However, the mere fact that he had taken into consideration irrelevant matters did not mean it had necessarily contributed to the eventual reasoning and the eventual decision. Where consent was refused for a mixture of good and bad reasons, the refusal would be reasonable if there was at least one freestanding good reason, and the decision would have been the same without having taken into account the bad reasons. The court held that the claimant's first reason for withholding consent, namely it could have a detrimental impact on the amenity value of the entire estate, was not reasonable, as the covenantee was not entitled to take into account matters that did not affect the benefited land. However, the second reason, that the development could threaten the future use and commercial value of the benefited land, was reasonable. It was freestanding and independent of the first reason. The claimant had followed a reasonable decision-making process. And finally, the courts found the claimant had come to a reasonable conclusion. And consequently, the refusal of consent was reasonable and not subject to challenge. Thank you. Next slide. And next slide. And this is our final case for today, which is SPS Groundworks and Marhill. This one concerned, it's a particularly interesting one. I think it's akin to McDonald's having to put warnings on their coffee that may contain hot coffee. It concerns a common law duty on a seller of land to disclose defects in title, but it also weighs that against the general common law principle of caveat emptor, which is let the buyer beware, and is something that I think we're probably all aware of, and also that you would imagine applied to sales at auction. So the facts of this are that the property was sold at auction and was described as having excellent scope for development. The seller did not mention in the auction brochure the presence of an overage agreement to which the land was subject. However, there was a legal pack for the property that was available to be downloaded from the auctioneer's website, and that included both a copy of the deed creating the overage obligation and a copy of the registered title, which included a restriction protecting the overage deed. The buyer viewed the property in person, but did not review the legal pack before making her bid at auction a successful bid. Immediately after winning, the buyer became aware of the overage and refused to complete the purchase. The seller later sold the property at a second auction at a lower price, and unsurprisingly on this occasion, disclosed the existence of the overage expressly disclosed it prior to the auction. Seller then sought to recover the shortfall from the original buyer for breach of contract for failing to complete on her successful bid. The seller's claim was initially successful, but on appeal to the High Court found in the buyer's favour on the basis that, number one, there was an equitable principle that if there is a defect in the title of which the seller is aware, the seller must provide full, frank, and fair information to the buyer, or a fair and proper opportunity to become aware of the defect. Now, evidently, the fact that the information was readily available in the auction title pack, and also the fact that the auction was expressly held to be subject to the common auction conditions, which provided the land was sold subject to all matters contained or referred to in the auction pack, that was not thought by the courts to be sufficient to discharge the common law duty of disclosure. And as I mentioned at the start, that does seem to be at odds with the perhaps better known common law principle of caveat emptor. However, the courts held that if no defects are specifically disclosed, the buyer may assume that there would be no unusual defects revealed in the legal pack, which would significantly affect the value of the property. This duty cannot be circumvented by contractual conditions deeming the buyer to have made necessary searches and inquiries and to have knowledge of any defects. So the key findings of this, it's a somewhat unusual decision, but it's a decision of the High Court, and it reinforces the importance for a seller to be absolutely squeaky clean and to draw a purchaser's attention to any defects in title and to avoid potentially misleading sales language such as excellent scope for development. It's particularly relevant in the case of auction sales, where often buyers have not instructed solicitors and there's not been the level of due diligence that would normally be expected in connection with a property transaction. But very much one to be aware of, and if in doubt, disclose, is a message from that one. So thanks very much, everybody. That's the Counter 3 case law. If anyone has any questions for any of the speakers today, then do please shout out. In the last case, was a buyer represented by a solicitor? I don't know is a short answer to that one, but I don't think so. Because certainly whenever I've represented people at auction, first thing you do is look at the title, especially if it's registered. And the very first thing I would do in this case is then say, there's an overage. Do you know about that? Do you still want to proceed? So I strongly suspect she was not represented by a solicitor, certainly at the time that the offer was made. Quite possibly she asked the solicitor to run an eye over the auction pack afterwards, and then discovered the existence of the overage. Although having said that, I think on the facts approached by the beneficiary, which was a parish council or a parish councillor, and they said, not really developable, don't you know? And if it is, we're entitled to a big chunk of the profit. Had they been represented by a solicitor, maybe the common law duty, the pendulum of the common law duties would have swung more in the favour of caveat emptor having more weight than the duty to disclose. So I suspect the courts, at the very least, would have taken that into account. And I've got another question. Is there a need to disclose a physical defect that is known to exist in the property as well as a title defect? Again, I suspect that it will all depend on the facts and I suppose the nature of the physical defect. But if, I don't know, for example, the seller knows that there is an unstable former tin mine underneath the land, and it's then sold with a description perfect for development, then that would certainly constitute a defect of which the potential purchasers should be made aware. But there is also the caveat emptor aspect to it as well. In this case, the purchaser had visited the site, but obviously there's not a big sign there saying here be overage, so that was of limited value. Sorry, can you insert a clause stating overage does not apply in the sale of the property? I don't know if that's aimed at me or Sonali. I mean, overage does not apply automatically. So if it was a sale contract and it included overage, then that would have been negotiated between the parties. If it was a transfer of land and there's no mention of overage within that transfer and the land was not subject to it, nor was any overage created in the transfer, then I would say it's a matter for negotiation and agreement between the parties.
Just to add to that, I'm not really sure if the question was addressed to me or Richard, but the agreed trigger does not need to be a sale of the property. It can be something else. But if a property is subject to overage, then more likely than not, the seller will have protected its position, as I mentioned, by way of a restriction on title, possibly. So even if the parties negotiate that overage does not apply to the sale, the original seller might have a different view on the matter.